Joining us this morning to talk about that, Senator Jack Reed. He's a Democrat from Rhode Island. He's also a member of the committee which crafted the health care law. And CNN's senior legal analyst is Jeff Toobin. We're going to start with you, Senator Reed, if we can. You heard Jeff Toobin yesterday describe this as a train wreck. Would you say that's how it's gone so far, sir?
No, not really. I think what yesterday demonstrated was there are serious questions to be asked, hard questions to be asked. That's not unusual. That's typical in a Supreme Court argument. The real discussions, I believe, begin once the lawyers leave and the judges in their conference begin to talk about the law. I think they understand the historic importance of this case, and I think they also understand the realities of this case. Health care is 17% of our GDP. It's 60% of bankruptcies have a major factor of health care cost. So I think they are looking for a way to sustain this legislation, not to strike it down. And I think also, too, they have to be conscious of what they might be doing in the future. You know, there are already people, in fact, for generations have spoken about Medicare as being an imposition of a tax for health care that I don't want or don't need. That'll pick up with great fervor if this decision is struck down. And I think they have this broad historic context.
You know, when you heard Donald Verrilli, really, I think Jeff stumble doesn't even have to describe it. It was just a little bit of a hot mess. I want to play a little bit of the audio from his arguments where he started choking up a little bit. Listen.
Insurance has become the predominant means of paying for health care in this country. Insurance has become the predominant means of paying for health care in this country. For most Americans, for more than 80% of Americans, the insurance system does provide effective access. Excuse me.
So he stops to take a drink of water, and then just a couple of minutes in, the other justices start peppering him with questions. Is this typical, or did it seem to be atypical from what you know, Jeff?
No, it's not typical. It was awful. I mean, that thing you quoted was his opening line to the justices. And, you know, these lawyers, they work for months to have a grabby opening line, something that will really focus the justices' attention. And that stumbling opening was how Verrilli started. And, excuse me, I'm having my own problem.
Judge and be not judged, Bishop.
Exactly. Which is a good reason why I should not be Solicitor General of the United States. But this is... it was a problem. Now, I don't want to overstate it. These justices, they know what they think about these issues. The lawyers, I think, really don't matter all that much. But, you want to put your best foot forward, and they didn't.
Hey, Jeff, this is Will Kane. I want to try to make this clear to the audience what we heard yesterday and see if you agree with me. The justices were constantly asking the Solicitor General for a limiting principle. Essentially, if we allow you to do this, what can't you do? And Scalia and Roberts used the example of food, and Alito used the example of burial insurance. And I think the mistake he made, tell me if you agree with this, is actually the same mistake that the senator just made. With all due respect, essentially he responded with a kind of policy argument instead of a legal argument. He never answered the question, where does your power end?
Well, and it was interesting. The person who really took on that question most enthusiastically was Stephen Breyer, who in many respects sort of took over the defense of the argument from the defense of the law from Donald Verrilli. And he said, look, it's up to Congress to define the limiting principle. We have political checks. If Jack Reed's constituents think he's doing a bad job and thinks he's overstating, they'll throw him out of office. But it's not the Supreme Court's job to decide what the limits of what Congress should do are. And frankly, I thought that was a lot more persuasive than anything Donald Verrilli said in defense of the law.
Let me ask a question of Senator Reed. Let's say, hypothetically, that this, in fact, is struck down. Can the bill live without the mandate, right? Because that's kind of the direction we're heading now. What happens next?
Well, I don't assume that's the direction we're heading. I think as...
I meant in terms of the conversation, not in terms of whether or not it would be struck down, sir.
Well, I think that I feel that the law will be sustained. I think Jeff said it very well, that these judges probably have a pretty good sense of what they're doing. They were pressing for a limiting principle, but as Jeff Gannett said very accurately, Justice Breyer pointed out, well, that's a sort of almost a case-by-case basis based on the legislation. So I think that they're going to give it a fair consideration, and I'm confident they'll uphold it. I think what they not only decide, but what they write in their opinions, and there'll probably be more than one opinion, will suggest if there's ways to modify it, if there's ways to make it constitutionally permissible in the case they do strike it down. So at this juncture to talk about, well, what's Plan B, I think we have to wait for this decision. And I think we can't essentially also relieve them of the need to make a fundamentally and historic decision about the constitutionality of this case.
Senator Jack Reed joining us from the state of Rhode Island, and Jeff Toobin as well. Nice to see you, gentlemen. Thank you very much.
Thank you.